Thank you, Madam Speaker, for the opportunity to bring closure to this debate. Madam Speaker, I have to say, sometimes we could just simply agree. I often wonder what the need for antagonistic debate is. I welcome the scholarly approach to the law that my colleague, the member for Chaguanas West, adopted today in answer to his submission as to, essentially it's a very narrow submission. The submission is firstly, number one, that the Court of Appeal has already decided that the procedure can flow. Certainly I agree with that position. I thank the member for Port of Spain South for a fantastic contribution today. He answered what I needed to say, so I just simply for the record put it. It's paragraph 27 of the very judgment that we both quoted from that sets out the rationale for the need for the amendment. It is because matters of formality, statutory matters of formality, exist in statute. They can at times result in a material miscarriage of justice beyond mere formality. So that's the simple point. The need for the legislation is to once and for all move us away from the need for the defendant being informed and for the defendant to provide, each defendant to provide consent. In default of that, magistrates who are creatures of statute will be bound by the four corners of the statute. It's as simple as that. The submission coming from Barataria Sanwan, Madam Speaker, what can I say about Barataria Sanwan? My opening remarks were largely directed towards that contribution coming from the Honourable Member. Sometimes you don't need to stand up and just say things. You just need to just admit to the narrow purposes of what we're about. So I'm characterizing my response that way. The Honourable Member's submissions included allegations that piecemeal law doesn't work and we need a holistic approach. I mean, for heaven's sake, Madam Speaker, how do you amend the laws of the Republic of Trinidad and Tobago, as diverse as they are, unless you amend them one by one? You cannot take a miscellaneous provisions bill, as Barataria Sanwan recommends, and amend all the laws all at once. I mean, to use the colloquialism, G's and H's, Madam Speaker, it just makes absolutely no sense for the Honourable Member to make a submission such as that. You have to, by the very rules of parliamentary procedure, take laws sometimes as standalone provisions, Madam Speaker. And therefore, Madam Speaker, I reject the absurd submission that quote-unquote piecemeal law is obnoxious. Madam Speaker, in addressing the submission coming again from Barataria Sanwan that we need to fix the system, Madam Speaker, prior to 2015, that was a systemic issue. Prior to 2015, all people could speak about is the system. Insofar as significant submissions were made by Barataria Sanwan, permit me to succinctly answer them as follows. We as a government have no longer confined ourselves to the system, because we have gone into the elemental pieces of what comprises the system. We have looked at judges, defendants, we've looked at evidence, we've looked at courtrooms, we've looked at rules. Suffice it to say, Madam Speaker, in answering Barataria Sanwan, the environment of justice is now quite simply, materially in a better state and condition. We have divisions of court, the family and criminal division. We have the children's division. We have the civil division. We have the probate division. In 2015, we had no criminal proceedings rules. In 2015, we had no substantively utilized plea bargaining or plea discussion arrangements. We had no amendments in terms of structures for the operation of courts by the way in which they function from rules. And Madam Speaker, when Barataria Sanwan says that the opposition is there to assist, for the record, The attorney at law, as far as I recall, who went to challenge the constitutionality of the criminal proceedings rules was Wayne Sturge, Senator Wayne Sturge from the United National Congress. The challenge on the evidence approach, on the interception of communication, the objection to anonymous witness evidence, every step along the way, the opposition has simply refused to assist the country on justice. Let me answer one other point by Barataria Sanwan. Barataria Sanwan said that this bill is not going to change the shape and smell and feel of justice effectively. It was just repeated by the last speaker. Madam Speaker, we make no allegation that this law is intended to fix the systemic issues inside of the system. It's part of the structure. That is what the member for Port of Spain South so eloquently put onto the record. And Madam Speaker, when we consider that the people of the Republic of Trinidad and Tobago can now go to court in a virtual setting. Madam Speaker, I was speaking with senior counsel in a particular matter yesterday, who reflected whilst he sat in Barbados that he had attended 4 courts in Trinidad and Tobago that morning, had gone to court in Belize and Antigua from the comfort of his living room in Barbados. And Madam Speaker, when you think of the Sean Luke matter, which is now out of the court system, the witnesses in that matter gave evidence. One of them in particular gave evidence from the back of a cab, a truck cab, at a pit stop, a trucking pit stop in the United States of America, in a judge-only trial for murder. When we brought the judge-only amendments, the opposition, the UNC, stood up and said, nobody will use judge-only trials for murder, and yet we have had many of them. And to all that I will say to Barataria Sanwan, when the United National Congress had the opportunity to drive justice reform by creating an entire Ministry of Justice alongside a Ministry of the Attorney General, alongside a Ministry of Legal Affairs, alongside a Ministry of National Security, we saw what you did. You brought the administration of justice law, and the only thing that came out of that law was the proclaiming of Section 34. Nothing else. In the context of this law, Madam Speaker, in the context of what is before us, this is part of the umpteen reforms that we have brought to life, which this government is convinced is opposite to the best interests of the people of the Republic of Trinidad and Tobago. Madam Speaker, Port of Spain South gave such an excellent example from a practitioner's point of view of how this law operates as it is and how it can operate as is being proposed by this amendment. It matters to this country that 500 people that are statistically involved in the utilization of Section 64(2) of this law, that 500 people's cases can progress, Madam Speaker. And therefore, for those 500 people who have a chance at feeling justice, at coming out of the system, Madam Speaker, it makes a difference. Madam Speaker, law can change culture. Law can change society. Madam Speaker, when we removed 104,000 motor vehicle and road traffic cases out of the magistracy's caseload. The magistracy's caseload in the context of this bill is 146,000 cases a year. 104,000 of those cases are for motor vehicle and road traffic matters alone. Having created motor vehicle violations as opposed to offenses, we now have statistically a 65-year low in road traffic deaths. But in the context of this bill, it matters that the caseload has dropped by 104,000 cases. And when you remove 8,500 marijuana cases from that 146,000, and when you remove 26,000 preliminary inquiry matters and treat with them instead in a different way, by way of sufficiency hearings under AJIPA, the Administration of Justice amendments that are to come to life after a short opportunity of reflection by the DPP and the judiciary. I'm awaiting their submissions, Madam Speaker. The intent is to abolish preliminary inquiries this year. Madam Speaker, we are confident that this bill assists in the reform of justice, Madam Speaker. So, Madam Speaker, I need only adopt the submissions of my very capable and most eloquent counsel and colleague, the Member of Parliament for Port of Spain South and the Member for Laventille West, and I need only say that I adopt their submissions. I've answered in brief form the comments coming from my learned colleagues opposite. I welcome the scholastic approach brought by Chaguanas West. I would just simply urge Barataria Sanwan, sometimes it's okay to just say, I agree, you know. It's not offensive. You will not be viewed in any less stature by just simply saying, I agree, Madam Speaker. I think that that is a position that we can all understand. So, Madam Speaker, in those circumstances, I need only say, I beg to move.
Honourable members.